and welcome to The Briefing, a weekly conversation with leaders and experts to explore the ideas shaping our democracy today. I'm Michael Waldman. I'm the president of the Brennan Center for Justice. And for those of you who are watching live, thank you for your patience. We have an important conversation today about the big challenges facing our Constitution and our country. The U.S. Supreme Court, as you all know, has enormous power and a massive role in our system. Next week marks the beginning of its term, and there are going to be some very big cases that are going to shape what our country looks like and shape what kind of democracy we have. There are going to be cases around democracy, around voting rights, around money in politics. Will the Supreme Court continue, as it has been, to be very active in knocking down a lot of those protections? And there will be a lot of significant cases around the issues of presidential power, what I think in many ways is the great constitutional issue of our time, at a time of an epic expansion of presidential power. Will the court stand up or not? We're going to find out. It's a big moment. There's a lot of change. Justice Clarence Thomas recently said a few days ago that precedent should not be regarded as gospel. We may see big changes. We're going to have a conversation about what's coming up in this potentially significant Supreme Court term. This conversation, I should note, is made possible by the Kohlberg Center on the U.S. Supreme Court here at the Brennan Center. And we're really fortunate to be joined by some of the most insightful experts on these topics. Dr. Kareem Crayton is vice president of our Washington, D.C. office at the Brennan Center, a political scientist and legal expert. And he and I will be joined by Professor Gilda Daniels of the University of Baltimore School of Law, a longtime expert on voting rights and voting rights law who had an important tenure at the Justice Department. We will be joined later to talk about these extraordinary issues of presidential power by Leah Goitein, co-director of our Liberty and National Security program and one of the country's leading experts on presidential power, familiar to so many of you who've watched these programs, and Leah Tulin, a senior counsel at the Brennan Center, who's been leading a lot of our litigation work on these very issues. Thank you to everybody for being part of this. So I'm going to start with you, Kareem. There are going to be some very big cases argued soon around voting and voting rights. What is the Voting Rights Act? That's a fairly basic question. What is the Voting Rights Act, and why has it been so important for equality and political participation in this country?
Thanks for the question, Michael. The Voting Rights Act, in many ways, is not just a law, but by many descriptions, a super law. It is a significant, extraordinary law that's meant to answer a real problem that we had in this country for a long period of time during the 20th century, that states wouldn't follow the edicts of the 14th and 15th Amendment to make sure that people who are entitled to the right to vote got an ability to cast the vote and have the vote counted regardless of race or color. What we know was in the South in particular, that was an especially pronounced problem through 1965, when, after a series of tries by Congress, they finally responded to a very graphic display of state power. You might sound familiar, going to stop nonviolent protesters marching to ask for voting rights. And once Congress saw that everybody recognized that this couldn't stand, they decided to adopt the Voting Rights Act. And it essentially says that it, much like the 14th and 15th Amendment, forbids states and other jurisdictions from adopting legislation or practices in law that essentially would deny or abridge the right to vote with respect to race. There's a particular part of the law, Section 2, that's at issue here, where Congress especially said, look, we're not going to just take those cases where the local jurisdiction or the state says, we intend to keep you out because of your race. We're going to take the more, I think, muscular approach to say we're going to undo structures that are the result of all these years of denial by saying if the effect of a proposal or a rule denies the ability of groups to have an equal opportunity to cast a ballot, this is where federal law comes into. And it has been really effective throughout the South, but really throughout the country. People at every jurisdiction level in government have been able to get more opportunities to cast ballots, to participate in elections, and actually get elected candidates that more connect to their interests. And it's had a dramatic change throughout. But as one piece of the civil rights puzzle, it really stands as really the crown jewel.
And, as so many people know, of course, this was won by the courage and sweat and blood of people like John Lewis and the other marchers at Selma, who were attacked by a mob, but also by law enforcement. And the public reaction was so intense, it led first President Johnson and then the Congress to pass the Voting Rights Act. It reflects an interesting dynamic, which is that throughout the country's history, only national action, in this case legislative or sometimes through the Supreme Court, can actually make sure that states don't abuse the rights of their own citizens. Now, the Shelby County case was the 2013 case where the Supreme Court gutted the most effective provision of the Voting Rights Act, what was called Section 5, where some states had to get permission in advance to change their voting rules. And at that time, John Roberts wrote, well, basically racism is a thing of the past. In effect, it's no longer needed. Justice Ruth Bader Ginsburg wrote a very famous dissent saying, well, that's like standing in a rainstorm, holding an umbrella and not getting wet, and therefore you don't need the umbrella. I'd say as a predictive matter, she was a lot more accurate. But Roberts said, oh, don't worry. There's still this other part of the law, Section 2. And it's not as good. You have to sue after the fact to prove discrimination. But nevertheless, that is there for citizens, for voters. And that's really what's being challenged potentially in front of the Supreme Court right now.
Right. And just one other point to mention in that helpful description about the more recent iterations of the Voting Rights Act, throughout every time this act was adopted, bipartisan groups of members in Congress and presidents of both parties signed this act. So when I call it a super piece of legislation, it really represents a national consensus to make real the 14th and 15th Amendments. But as you point out, it is under attack.
And this is something where lots of people say they don't want judicial activism, but on the issues of democracy, on voting, on money in politics, and other things as well, largely, this Supreme Court under John Roberts, who marks his 20th year as Chief Justice right now, it's been very activist. And this law now, its full validity is really being challenged. And I want to actually turn to Gilda. The court actually asked the question, is this constitutional under the 14th and 15th Amendment? Can you tell us a little bit about this specific case? Maybe also tell us a little bit about your own work in the government on these very issues, and then about this specific case and how it came about and what might happen.
Wonderful to be here. I served as a deputy chief in the Civil Rights Division voting section at the Department of Justice under both the George Bush administration and the Clinton administration and the George Bush administration, and serving as a deputy chief. And certainly Section 2 is a viable and very important part of the Voting Rights Act. And certainly, while I was in the Department of Justice, it was the Department of Justice served as the nation's litigator. And in serving as the nation's litigator, we understood that it was our job to enforce certainly federal legislation and federal laws. And the VRA, certainly the Voting Rights Act, is certainly a very important part of our work in the voting section. And I think it's important to point out, and thank Dr. Crayton for the overview of the Voting Rights Act. I think it's important to point out that constitutional amendments were not enough. Right, that we certainly have we have more constitutional amendments that affect the right to vote in this United States Constitution than any other right. Yet, constitutional amendments were not enough to ensure that persons had an equal opportunity to participate in the process. Right, and so Congress passed and President Lyndon Baines Johnson signed the Voting Rights Act, as you point out, Michael, after a lot of blood, sweat, and tears. And in the face of terroristic acts, murders for persons participating in registering people to vote and other actions. And we got the Voting Rights Act, which has been a monumental in ensuring that there's an equal opportunity to participate.
I really want to underscore one thing you just said. You'll often hear people say, oh, the right to vote, that's not in the Constitution. It's actually literally mentioned several times, but always in the amendments. But even so, it took legislation and enforcement to actually make that right real. And the Voting Rights Act really was the creation of a multiracial democracy in the United States, or at least the potential for it, which of course makes our democracy in some ways younger than many other countries, even though our Constitution is older. And the Supreme Court always understood this law to be important, to be strong. It upheld it repeatedly. As we discussed in 2013, it took a hammer to Section 5, but Section 2 was still there. So this case, Louisiana versus Calais, it deals with redistricting. It deals with a congressional map. Tell us a little bit about this case and how it got to this point where everything is on the line.
Well, this case centers around Louisiana's congressional map, which created 2 majority Black districts. And the state had previously adopted a map that had only 1 majority Black district, which certainly was challenged under Section 2 of the Voting Rights Act, claiming that it diluted Black voting power. And a federal court agreed and ordered a new map. So there was a remedial map. So after the remedial map was passed, that created a second Black district, a group of non-Black voters sued, claiming that the new map itself was an unconstitutional racial gerrymander under the 14th Amendment's Equal Protection Clause. Now, the district court ruled that the map violated the Equal Protection Clause because race predominated in drawing the districts, and they said the plan was not narrowly tailored to serve a compelling government interest, and they've certainly looked to statements made by the legislature and saying that they were intending to draw a second majority Black district. And the problem in this case is that we have conflicting decisions, right? You have a lower court decision that said that a remedial map was in order, was needed, and once that map was drawn to remedy certainly racial discrimination in the drawing of the congressional districts, you had a challenge to that map where they questioned the use of race in the redistricting process. Now, we know in the Shaw versus Reno case, they said that race could serve as a factor, but it could not be a predominant factor in the drawing of the maps. And we have an issue in this case where the case was argued and now it's set for re-argument in this new term. And in its re-argument, Louisiana is raising a broader claim that all race-based redistricting is unconstitutional, which would represent certainly a much more radical limitation, certainly on the law. And we have the Supreme Court asking the parties to brief whether the intentional creation of a majority Black district as a remedy for vote dilution under Section 2 violates the 14th and 15th Amendment. So they are questioning whether Section 2 of the Voting Rights Act can continue to serve as a compelling reason to actually draw these remedial districts.
And that is really what's
on its head.
That is what's so unnerving in a way about this. It's in some ways, it's the use of the language of racial equality to actually undermine actual practical steps to achieve representation and equality in the very way that both the constitutional amendments and Congress intended, and that has been upheld for decades and decades. And in a way, it sort of follows, if you think about it, on the affirmative action decision, and how it used similar language of equality in that case to undermine the steps that have been taken to actually boost participation in our educational institutions. And the fact that they ask this question is part of what has people so rattled. When the Supreme Court asks this question, it often signals at least that 4 of the justices think that it might be unconstitutional to protect voting rights through the Voting Rights Act. So I'm going to turn to Kareem. What is the potential consequence if this case goes wrong? I'm tempted to say goes south, but that would be not the right way to say it. But what would be potential consequences in terms of representation in Congress, but more broadly in our political system?
Right. It's an important question because at stake in this case, as Professor Daniels mentioned, there are two congressional districts that reflect minority political opportunity. The same is true for about a half dozen districts that have either been litigated, like my home state of Alabama, or are in the midst of litigation. There are easily half a dozen of those throughout the South. But beyond that, we can think of the number of districts that reflect current representation by non-white members, a lot of which are the result of Section 2 work. And they, if you look at just the Asian American Pacific Caucus, the Hispanic Caucus, the Black Caucus, represents about 1 of every 4 members of the House of Representatives. But beyond that, even, this case is about Congress. But as we've pointed out in our writings, more than 3/4 of cases bringing up Section 2 in the district courts involve local district, school districts, city councils, commissions.
At-large elections, firefighting districts, all these kinds of the nitty-gritty of where discrimination can happen, but also where government either serves people or it doesn't.
Absolutely. And that's all across the country. And that really reflects the work, the track record of the Voting Rights Act, particularly Section 2, at enhancing representational opportunity. So we see possibly all of these districts that have been created and other means of changing representational rules being up for grabs if the Supreme Court takes a hatchet to Section 2. It's also worth noting a number of states have adopted their own states' voting rights acts. And so those efforts to try to create protections beyond what the federal government has said might also be up for bids.
It's not just a matter of overweening federal power, but knocking those out potentially as well. We're going to put a pin in this topic. Voting rights is going to be a very big legacy of this term of this court. We're going to discuss in another one of these conversations about the campaign finance cases that could do damage. And I'm going to turn to what are a real flotilla of cases coming toward the court dealing with this issue of presidential power. We all know that this is a year where there is a really dramatic effort to expand the authority of the presidency, we believe, to break through a lot of laws and a lot of practices by Donald Trump and his administration. And one of the very big cases on that is coming up. And the Brennan Center is very involved in these issues in a variety of ways. But the case that is going to be argued in the 3rd week of November has to do with the tariffs, which the Independence Day worldwide tariffs that President Trump announced that has become the centerpiece of his economic policy. And many people watching this might have thought, well, wait a minute. Does a president have the power to set tariffs all on their own without any authorization by Congress? Presidents can't set tax rates, and this is a tax. Well, we said no, they don't have that power. And Leah, Tulin, you have been involved in these cases. What can you tell us about this big tariff case? And what is the argument the plaintiffs are going to make in challenging it?
So first, I'll give you some quick background. As everyone surely knows, the president has announced a wide range of tariffs since taking office in January. Several cases have been filed, both by private businesses and by states, to challenge the tariffs, and 3 of those cases have now been consolidated in front of the Supreme Court. The statutory authority that the president has relied on for all of the tariffs is called the International Emergency Economic Powers Act, or as we like to call it, IEPA. So the question that is at the root of these cases is whether, through its enactment of IEPA, Congress gave the president the authority to impose the challenged tariffs. The plaintiffs are arguing, and the lower courts that have opined on that question have agreed, is that IEPA does not give the president that authority.
And what does the Trump administration say in response to that? My sense is they're basically saying, we're in so deep that getting us out and getting the country out of this will be too destructive.
Yeah, so the Solicitor General has a knack for channeling the Trumpian rhetoric. And so to quote from the government's cert petition, these tariffs present a stark choice. With tariffs, we are a rich nation. Without tariffs, we are a poor nation. It goes on to say that the court decisions concluding that IEEPA does not authorize the president's tariff cast a pall of uncertainty upon ongoing foreign negotiations that the president has been pursuing through tariffs over the past 5 months. But when you strip away that rhetoric, the legal argument that the administration is making is pretty straightforward. As its name indicates, IEEPA is an emergency statute that gives the president the authority to regulate importation to deal with an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. The administration says that this gives the president broad discretion to impose tariffs when, as he has here, the president declares a national emergency. So the dispute between the parties really comes down to whether the statutory terms regulate importation includes the power to impose tariffs. That said, there are some really important questions about the separation of powers and the relationship between the three branches of government that are very much at play in this case. One of them is whether and how the major questions doctrine is going to play into the Supreme Court's decision. This is essentially a rule that the Roberts Court has announced to say that when interpreting its statute involves a question of deep economic and political significance that is central to the statutory scheme, the president has to point to clear congressional authorization for that asserted power. The lower courts concluded that the president's interpretation of IEEPA would run afoul of that doctrine, so we'll have to wait and see whether the Supreme Court agrees with that. The case also implicates potentially the non-delegation doctrine, which is another Supreme Court created rule or doctrine that essentially prevents Congress from delegating authority to the president without providing an intelligible principle for the executive branch to follow. The plaintiffs in this case have argued that interpreting IEEPA to allow for tariffs would violate the non-delegation doctrine, and some of the lower courts have agreed with that as well. There's also a question hanging over this case about the scope of the president's emergency powers and the appropriate scope of judicial review when the president invokes emergency powers. In this case, the administration argues that the courts have no authority to second guess the president's determination under IEEPA of what constitutes an unusual and extraordinary threat to the national security, foreign policy, or economy of the United States. None of the lower court decisions have addressed that in great detail. They've decided on other grounds. But our view, which we've explained in a friend of the court brief, and we'll explain again in a few weeks, is that the court can and should review that question, which is a matter of statutory interpretation. And it's especially important for the court to do that here, where we're talking about a matter of great importance and a statute where that Congress passed to actually specifically cabin the president's emergency powers.
It seems to me that ultimately this is a test of the court's backbone as much as anything else. Are they willing to stand up to this administration in this very high-profile way? I mentioned the steel seizure case. That was in 1952, and every one of those justices had been appointed by a Democratic president, but they were willing to stand up to Harry Truman when he tried to seize the steel mills during the Korean War. Will these 6 supermajority justices be willing, and the others, be willing to stand up to a president who often appointed them?
You know, we'll have to wait and see. The majority of judges who have looked at these cases have ruled against the president, but 4 appellate judges on the federal circuit did dissent from the decision determining that IEEPA doesn't authorize the tariffs. So this isn't a situation where no judges have been willing to go along with the president's theory, but the vast majority of judges who have looked at it have come out against the president. I think it will be really telling to see how the Supreme Court handles the major questions doctrine in this case that I mentioned before. This is largely a creation of the Roberts Court, and the court has only ever applied it to invalidate actions by Democratic presidents, with the most high-profile example being in Biden versus Nebraska a few years ago, which is the student debt relief case. Here, the Constitution expressly gives Congress, not the president, the power to tax and to regulate foreign commerce. And the Supreme Court has repeatedly said that the power to regulate is not the same as the power to tax. So in Gibbons versus Ogden, a very famous Supreme Court case from 1824, Chief Justice Marshall said the power to regulate commerce is entirely distinct from the right to levy taxes and imposts. That case law, along with the major questions doctrine and the fact that everyone agrees this case will have enormous economic and political consequences, makes it a good candidate for applying the major questions doctrine. And so seeing whether this conservative court is willing to go in that direction in this circumstance, I think will tell us a lot about whether they're willing to stand up.
So I want to turn to Liza Goitein. Liza, you have been a Paul Revere warning about the emergency powers that presidents can use or abuse, and warning that presidents are going to try, and that this president would try to use the military inappropriately in domestic settings. That's obviously happened quite a lot. What are the cases that might come before this Supreme Court around the use of the military?
There are a few, actually. The fundamental legal issue here is whether the president can use federal troops to quell civil unrest or to execute the law. And that is something that is normally prohibited by the Posse Comitatus Act. This is an incredibly important protection for individual liberty and for democracy, because if the president can use the military against the people of the country, that can be a very powerful tool to either suppress or chill the rights of the people. There are statutory exceptions to the Posse Comitatus Act, and historically, presidents have deployed troops in situations where state and local law enforcement were entirely overwhelmed and asked for help. And also situations like during the civil rights era, where state and local law enforcement were actually complicit in either obstructing federal law or just, not protecting victims of violence, civil rights marchers and African Americans. We don't have those circumstances here, and yet Trump has already deployed troops in 2 cities, has authorized deployment of troops in 2 additional cities, has requested deployment of troops in Memphis, and in none of these cases do we have these sort of the usual justification that has been sufficient in the past to trigger the exceptions to the Posse Comitatus Act. Lawsuits have been filed in Oregon, in California, and in the District of Columbia. The California lawsuit is furthest along. In that case, the Ninth Circuit did hold that the president had the authority to federalize the National Guard, and the Ninth Circuit concluded that it was bound by 200-year-old case law to extend significant deference to the president on that point. However, the district court judge subsequently held that the Guard was still bound by the Posse Comitatus Act. So even though the Guard could be federalized, once deployed, they could not do things like crowd control or riot control or traffic control or security patrols, all of which would violate the Posse Comitatus Act. So that is now up on appeal to the Ninth Circuit, but we could see that case moving up to the Supreme Court.
As you've pointed out, courts generally are very deferential to presidents on things like foreign policy, military policy. Why would they potentially be willing to say to President Trump, this time, this is not something where we're going to show deference?
It's true that courts ordinarily show deference to the president in matters of emergencies. But that deference is not absolute. One of the things that's come out in a lot of the lower court decisions that we've seen in the last few months is that courts are empowered fully to interpret the terms of a statute and to decide what Congress intended in using those terms. And even for assessments of whether the facts on the ground fall within those terms, even in situations where the courts might otherwise show deference to the president, there are exceptions that the Supreme Court has recognized for a situation where the president acts in bad faith, where he makes an obvious mistake, where he exceeds a permitted range of honest judgment, or whether he's acted in a way that's manifestly unauthorized by law. And because what we're seeing from President Trump is really so unprecedented and so outside the bounds of what courts have deferred to in the past, there's certainly a possibility that the courts could look at this and say this is different. Even just in terms of just the context of how the court is going to be looking at these cases. In the previous 9 administrations, not counting Trump 1, presidents deployed troops a grand total of twice to quell civil unrest or to enforce the law. And already President Trump has done so or is in the process of doing so 5 times in just a little over 8 months. The justices are not immune to that sort of context, and it does bear on whether these claims that everything is an emergency can be credited.
Earlier this week, as you know, in this extraordinary scene, President Trump and the defense secretary met with all the generals who'd been summoned from all over the world. And the defense secretary, it seems, lectured them that we shouldn't have fat generals. And I was trying to rack my brain about what generals have been fat and quite successful. I think Nathaniel Greene, who founded the U.S. Army, or the Continental Army at least, would not have met Hegseth's test. But President Trump said some things that were really chilling. He said that the Army was going to now have a training ground in the cities. He said that the goal was to fight the enemy within, and that we were now going to be using the Army in inner cities, as he said. That's pretty chilling stuff. Will that kind of thing reach the court? Will they just pretend that didn't happen?
Well, the speech itself isn't going to reach the court. There's no way to challenge a speech in litigation. The actions that he takes pursuant to this express desire to use American cities as a training ground for the military, I mean, let's just pause for a second. That is unbelievably shocking. The military is trained to fight and destroy an enemy. That's the training that soldiers receive. And to have them practice that training in the streets of American cities is really beyond anything I ever expected to hear a president of the United States say. That statement cannot be challenged in court. But again, it is context. And I think the justices are going to hear that. There's a line that Justice Gorsuch wrote in a dissent in a case a few years ago where he said, there comes a time where we cannot be ignorant as judges to what we know to be true as citizens. That's probably not verbatim, but it's something close to that. And I think the backdrop for these deployments in terms of what the president said in his speech is something that is going to color potentially the way the judges are looking at these deployments. If nothing else, it really shows that Trump does not view them as a last resort, which is what the law contemplates. The law contemplates that the military will be used as a last resort when civilian law enforcement is overwhelmed and just can't do it or won't do it. Trump's statements indicate that he's not using the military that way. He sees this as just something the military does in American cities. And that is not consistent with the Posse Comitatus Act, as well as being extremely dangerous.
Congress can do something about these emergency powers. They're created very often by statute. What should Congress do?
One thing Congress should do is to make it easier for Congress to shut down presidential abuses of emergency powers. Right now, if Congress wants to intervene, it basically has to pass a law by a veto-proof supermajority of both houses, which is nearly impossible to do in today's political climate. But what Congress can and should do is to create a time limit on how long the president can use these emergency authorities without congressional approval. So the authority would expire after a relatively short period of time unless Congress voted to extend it. That wouldn't necessarily prevent all abuses or stop all abuses, but it would help to tilt the balance back in the direction of having meaningful checks. Congress should also amend these domestic deployment authorities to more narrowly and specifically define the criteria under which the president can use the military domestically. These laws, like the Insurrection Act and 10 U.S.C. 12406, that's the law that Trump has used to federalize the National Guard in Los Angeles and in Portland. These laws were clearly intended to be used only in extreme emergency situations, but they're old laws and they are written in vague and archaic terms that really don't provide the clear constraints that are needed. So Congress should fix that. And finally, Congress should clarify that courts have the authority to review presidential exercises of emergency powers in order to make sure that the limits in those powers are enforceable and are enforced.
Is there something our viewers should take away from this conversation? What is it that you want them to know? What's one thing?
I think there may be an impression that's out there, and I think some of Trump's statements have probably contributed to this impression, that when the president declares an emergency or invokes emergency powers, that all bets are off and that he can sort of do whatever he wants. That is not the case. There is law that governs the use of emergency powers, and that law can and must be enforced. The Supreme Court, and I mean this Supreme Court, has already shown its willingness to place limits on the president's use of emergency powers. I'm thinking about the Alien Enemies Act. That is a wartime authority that President Trump used to summarily deport 137 Venezuelans to a prison, a notorious prison in El Salvador. The Supreme Court intervened twice, and the first time held that these individuals were entitled to due process, including notice and a reasonable opportunity to file a habeas petition. And the second time, after the Trump administration was giving notice that wasn't reasonable, the court stepped in and said, this notice is not reasonable and no more deportations in this case until further notice by this court. There's also the fact that the next emergency powers case that the Supreme Court is going to hear, which is on the issue of tariffs, is about something that is of particular concern. These tariffs are of particular concern to a lot of conservative constituencies. So I would not assume that emergency powers are going to go unchecked by the Supreme Court.
I agree with everything that Liza has said about, watching and not assuming that the court is just going to defer to the president's invocation of emergency powers. And I certainly think that the rulings in the Alien Enemies Act cases that we've seen are a point of light in that. I think this term is a really important one to watch because and there will continue, no doubt, to be cases that come up through the shadow docket and through on the court's emergency docket. This term is the first test of where, on the merits, in a reasoned way with time to deliberate, this court is faced with some incredibly important questions about executive power, about the separation of powers. And I think we just all need to be very watch closely to see how things come out. And I think that will give us a lot of information about what we can expect moving forward.
Professor.
Well, I think what I want people to understand is that we are really talking about democracy, or we hear a lot about red and blue states or Democrats versus Republican. We're really talking about our democracy. And I think that if we make, as well as racial justice, right? And so these are issues that I think are at the forefront, particularly this Louisiana versus Calais case, and certainly will come around in other issues as well. But I think it's important to certainly to stay vigilant, and certainly the role that the Supreme Court is playing in diminishing democracy, and certainly to continue to have events like this so that we can inform people and educate people about what is going on, what's happening in the courts, as well as the legislature, and that we can all be aware of certainly how we can hopefully create this more perfect union, and that to do so, it will certainly take we the people to do that.
Thank you so much, and thank you for being part of it. I'll ask you the same question, Kareem, Crayton, and I'll give one or two of my own thoughts.
Sure. Well, we've told a story today that is obviously factual, but it can be a little bit of a downer, right? The court is a lot more conservative than it used to be, but it's also a court that gave us, just a few years ago, a Section 2 case that we can be cheering about in Milligan, where the court said that there was a valid court decision to find that Alabama had violated Section 2 of the Voting Rights Act. That was just 2 years ago. And it was the same year, only weeks apart from when it issued Students for Fair Admission, the affirmative action case. So it's not as though this court is unfamiliar with how to support Section 2. The question is whether they can be reminded that they should do it again. To sort of be reminded of the law that they said was constitutional and that they applied in practice should continue to be applied in practice. Second thing, Congress, you mentioned it earlier. Elections happen, they continue to happen, and for as long as they happen, they will depend on people showing up and casting ballots. And so whether you're talking about who appoints a person to the Supreme Court, who gets to adopt a law that puts in national standards, it really matters at every opportunity for people to participate in the vote. And that's what ultimately drove those people across the bridge in Selma to make basically their bodies a sacrifice for the goal of making real the 14th and 15th Amendment. So if there's anything that we can do as an individual person in the public, it's really to participate and bring people along.
Thank you. And it is hard to top that. And I just want to say, this is a reminder that the Supreme Court has a lot of power, but that power depends on all of us. The court's ability to have its place in our constitutional system, the court's ability to have its rulings followed and even at times revered, has to do with its credibility and whether it is willing to stand up for the rule of law and the Constitution. A lot of that has to do with all of us. That's why we at the Brennan Center, among other things, are so strongly supportive of term limits for Supreme Court justices to recognize that nobody should have too much public power for too long. And the reason we care about that is because it's really important that we have a Supreme Court that stands up, that does the right thing. We're going to find out this year whether they're going to rise to the moment when it comes to voting rights, when it comes to other issues of electoral democracy. Thank you to all of you for sticking with us. Thank you for caring. And thank you for being part of this great effort to form a more perfect union. I'm Michael Waldman, president of the Brennan Center. Have a good day.